All right, guys, it's time to do my least favorite type of video. Okay. And that is a video where I have to correct a mistake. And I have to correct this mistake that I made in yesterday's video about the lawsuit between Bennie Thompson, Donald Trump, Rudy Giuliani, Proud Boys, and Oath Keepers. I've always had a policy on my channel where if I make a mistake of law or a mistake of fact, I will correct it as publicly as possible. I think that's a core of integrity, is to own the words that you used, to acknowledge mistakes, and to correct them in the best way that you can. And this is the best way that I can do it. So as a result, I have unlisted the other video. It's still there if you have the existing link, but I didn't want more people to find it and get the wrong information before I could update and correct it to have this information, which will be correct. And at the end of this video, after I explain the mistake, I will explain why I believe that the ultimate result that I talked about in that video, in which I think that Donald Trump and Rudy Giuliani and even the Proud Boys and the Oath Keepers do not actually lose this lawsuit. I believe that result to be the same, but for different reasons. So the mistake that I made was I asserted in that video that they would win because this pleading failed to assert a race or class-based distinction. Race or class-based distinctions, the classes we're talking about are those Title VII civil protected classes: age, gender, national origin, marital status, these sorts of things. These types of protections that exist where some people can discriminate based on a type. Those are disfavored in federal law, and so these race and class-based distinctions existed. I asserted that Section 1985 required this in all of its cases, and that is not correct. Okay, let's be very, very clear. That is not correct. Now, how did I get this wrong? Well, Section 1985, which is 42 U.S. Code, Section 1985, is broken down into 3 paragraphs. It originally wasn't, but it was cleaned up and broken up into 3 paragraphs. And those 3 paragraphs assert 5 different types of conspiracies to interfere with rights or duties of people in the United States, of different groups of people. And when they were doing this, when they were passing this law, it was a response to violence specifically against Black Americans following the Civil War. Now, they had passed the 13th, 14th, and 15th Amendments, and this was one of the sections that they passed to give teeth to those amendments. Because even though you may have rights on paper, if those rights aren't enforceable, then they might not be rights at all. And you could argue that people could go to state courts, but as you may or may not be able to figure out, if you tried to go to state court as a Black man in Mississippi in 1890, you might not get the most favorable treatment. So they wanted to create a federal avenue to give better representation and better opportunities for people whose civil rights were being abused back in the Reconstruction era of the United States. So they created this law. Now, when they're passing this law, they had a debate about just how far this should go. And what they decided was any conspiracy that involved certain federal issues was going to be covered. Any deprivation of civil rights related to federal officials and the commission of their official duties, like Bennie Thompson, federal courts, jurors, and witnesses. So you can't interfere with any federal court or intimidate any federal witnesses through a conspiracy. And then the third one is interfering with federal elections through a conspiracy. Any of those things do not actually require that race and class-based distinction that I mentioned in the last video. Now, the other 2 types of conspiracies involve depriving people of civil rights in state courts and just in state, in what would traditionally be state right issues. Okay, so states enforce the vast majority of your rights. If your rights are deprived, usually you're going to the state. Unless for some reason you can't trust the state, you need to go to the federal government because the state is actually depriving you of your right. Otherwise, you handle your state rights in state courts, your basic rights most of the time in state courts. That's just kind of how it goes. And so any of those conspiracies to interfere with state courts or your state protected rights those needed a little bit more. They weren't directly in the purview of the federal government. So they said, if we're going to reach federal power into states, we need to limit how far we reached it. Imagine that, legislatures wanting to limit the amount of federal power being exerted rather than maximize it. Those days seem to be long gone now. So they said we need to limit this to specifically these race and class-based distinctions. That's why we're going to do this, only in those types. Now, interestingly, even though that's only 2 of the 5 different types of conspiracies that exist under this statute, those make up the overwhelming majority of case law. And let me show you what this looks like. All right, so this is a research tool that a lot of lawyers use. In particular, this is Westlaw Edge. This is very up-to-date research software that lawyers have access to when you pay for it. And this is very, very expensive stuff, okay? And this is how I research legal issues when I don't know about them or I need some case law or a citation, both for this type of job and when I'm practicing law. And in this case, if you notice the notes of decision section up here, there are 1,913 decisions about Section 1985. Now, it's not broken out into the 3 subsections. So there are almost 2,000 cases that speak specifically to this. And I have the section up about the complaint right here. And if you saw the last video, I actually read the names of these top couple cases about how all of them required this sort of civil rights approach with race and class as a protected category. And you needed to plead a specific animus towards that race or class distinction to survive a claim. And that is, like I said, the overwhelming majority of case law around pleading on these 1985 claims. And that's why I got it wrong. Now, a friend of the show, a fellow lawyer, reached out to me and said, hey, I think you might have misstated this. Can you check into it? So I went and looked as soon as I could, which was last night when I got home. And sure enough, he was correct and pointed out my error. And I'm really thankful that he did that because I don't like giving out bad information on the show. I feel like that is not a good thing for the show to do. And that's why I wanted to correct it today. So my mistake for doing that, but the reason why is there are thousands of cases on it. Now, there are thousands of cases on this statute and only like 4 of them, and I'm not exaggerating, actually address how pleading standards go for 1985 subsection 1, which is at issue in this case. And in those cases, they are clear that the racial animus and the class-based animus requirements are not there for subsection 1. Now, again, I missed it because those cases actually required a little bit of extra digging and looking specifically for that specific issue related to that. And just so you know, in that entire list of 1,913 cases, there's only 1 that is specifically broken out by subsection 1, and it has nothing to do with this issue at all. So I did do research on this to try and figure this out, but that research was not complete, and therefore that's why I made the mistake. Now, with that being said, I've spent 8 minutes explaining why I got this wrong. Let's talk about why the ultimate result will be the same, in my opinion. Okay? And the ultimate result is still a failure of the pleading itself, but for a different reason. And the reason is a little bit less simple, but it's just as important. And that is that there are federal pleading standards that are a line of cases called Iqbal-Twombly, the Iqbal-Twombly standard. And that's based on 2 different cases about the sufficiency of pleading a complaint in federal court. And what they basically boil down to is the idea that you have to make a claim upon which the court can grant relief, and that claim has to be supported by some factual assertions to allow a court, and most importantly, a defendant, to know what is at issue, what facts are at issue supporting that specific claim. And they have to be pled specifically, not generally. In the Iqbal-Twombly cases, they made conclusory statements. They made statements of legal conclusions about some of the elements of their civil causes of action. What they didn't do was show factually how those causes of action were linked to the actual defendants in the case. And I think the same is true here. We're going to do the same thing we did in the other video. We're going to look at page 2 here. I guess it's page 3 of the PDF. And the PDF will be linked down in the description below if you want to find a copy of it and read it for yourself. It's 33 pages, so we're not going to go through all of it in this video. That would take a really long time. But we're going to just read this first part of the introduction, and then we're going to jump down to page 30 of the PDF, and we're going to read the specific count, and then I'm going to tell you where they fail, in my opinion, on this one. Okay? So on and before January 6, 2021, the defendants Donald Trump, Rudy Giuliani, Proud Boys, and Oath Keepers conspired to incite an assembled crowd to march upon and enter the capital of the United States for the common purpose of disrupting, by the use of force, intimidation, and threat, the approval by Congress of the count of votes cast by members of the Electoral College as required by Article 2, Section 1 of the United States Constitution. That is a conclusory statement. It contains a legal conclusion. 2 of them, actually. Conspiracy and incitement. It doesn't say how that they did that. Now, they're going to spend a fact section attempting to do that. I'm not trying to downplay what they say here, but I just want to point out that this is the allegation. This is not sufficient for a federal pleading. You can make this allegation. The court has to ignore this as part of that allegation. And what they have to do is look to the pled facts, and they have to attach those facts to these legal conclusions. And only if they can attach those facts, assuming they're true, to the legal conclusions, can they then entertain the case at all. If they can't, it has to be dismissed. Okay? In doing so, the defendants each intended to prevent and ultimately delayed members of Congress from discharging their duty commanded by the United States Constitution to approve the results of the Electoral College in order to elect the next president and vice president of the United States. Again, we have legal conclusion here. Intent to prevent. That's what they did, and then they ultimately delayed it. So again, they'll have to go ahead and plead through specific facts to go ahead and make this intending to prevent and ultimately delaying into a reality. Now let's skip to page 30 of the PDF, which is here. Cause of actions. Actually, it's page 31. Violation of the Ku Klux Klan Act. All right. So this is the underlying cause of action. It's the only cause of action that they requested the court. So it says, under the Ku Klux Klan Act 42 U.S.C. Section 1985, subsection 1, defendants may not conspire to prevent by force, intimidation, or threat any person holding any office, trust, or place of confidence under the United States from discharging any duties thereof, or to induce by like means any officer of the United States to leave any place where his duties as an officer are required to be performed, or to molest, interrupt, hinder, or impede him in the discharge of his official duties. Defendants Trump, Giuliani, Proud Boys, and Oath Keepers plotted, coordinated, and executed a common plan to prevent Congress from discharging its official duties and certifying the results of the presidential election. Again, this is a conclusory statement. Now, in your intro and in your cause of action section, you can use conclusory statements. That's okay. They're just not sufficient on their own. They have to be supplemented by appropriate facts. And personally, I think what you should do is include the paragraphs where you allege those specific facts in your cause of action statement. But people draft pleadings differently all the time. That's just how I prefer to do things like this. In furtherance of this conspiracy, defendants Trump and Giuliani engaged in a concerted campaign to misinform their supporters and the public, encouraging and promoting intimidation and violence in furtherance of their common plan to promote the re-election of Donald Trump, even after the states had certified election results decisively showing he lost the election, and to disrupt the legally required process before Congress to supervise the counting of the Electoral College ballots and certify the results of that count. As a result, Donald Trump acted beyond the outer perimeter of his official duties and therefore is susceptible to suit in his personal capacity. They had to get around the fact that he could have been acting in his official duty as president, and therefore he might have some immunity. So that was the purpose of that section. The activities alleged above were undertaken by all defendants as co-conspirators for the purpose of seeking to prevent Plaintiff Thompson and other members of Congress from certifying former Vice President Biden won the presidential election. As a result of the acts set out above, paragraphs committed in furtherance of the conspiracy, Plaintiff Thompson was hindered and impeded in the discharge of his official duties, and suffered the deprivation of his right to be free from intimidation and threats in the discharge of his official duties, as explicitly protected under the Ku Klux Klan Act. During the time when the Capitol was under attack, Plaintiff Thompson suffered emotional distress. As a result, he wants compensatory damages, as the unlawful actions taken by the defendants were malicious and in reckless disregard of federally protected rights. He wants an award of punitive damage to punish the defendants for engaging in a concerted act. Okay. So here is, this is the underlying issues of the case as laid out. Now, why do I think this will fail? Because despite all of that, reading through all of the pages of facts, which I did, they never actually allege the agreement between the co-conspirators. And this is a critical element of conspiracy. Trump, Giuliani, Proud Boys, and Oath Keepers all have to, at some point, come to agreements which would further the conspiracy. You can't have an accidental conspiracy. The very nature of a conspiracy is that minds came together, met, and decided that they would commit to this plan of action that would produce some unlawful outcome. That's how a conspiracy works. That's actually a requirement of pleading all 5 of the types of conspiracies covered by 1985. And it's a failure in this case. They don't actually allege it. Now, here's the thing. You can say that Donald Trump agreed with Rudy Giuliani to do this thing. But, and this is going back to what I talked about earlier with Iqbal and Twombly, that line of cases, it's not sufficient to merely assert that there must have been some sort of agreement because they acted in a similar way. These are specific, like that Twombly case is specifically about this. That in Twombly, they were alleging a conspiracy between telecommunication companies to basically organize how they do business and be anti-competitive. The one thing missing from Twombly's entire case was his actual fact-based assertion that these companies were working together in an anti-competitive way. I mean, everybody could see it. This is the telecom industry and how it works, and everybody can see that they're anti-competitive. How many ISPs or phone services do you have in your neighborhood? Probably 1, maybe 2. Maybe 2. You don't have 10. You don't have 50. You're right. Compare it with how many grocery stores are in the same amount of space, and you'll start to get an idea. There's really only 1 cable service, maybe 2. 1 ISP, maybe 2. 1 phone company, maybe 2, that service large swaths of the United States. But he could never actually allege that they had a meeting or an email or a phone call or dinner or anything that on any particular date between any particular people that would actually allow them to generate this conspiracy. And this complaint fails here as well. This complaint goes ahead and lays out how a conspiracy might have unfolded if you take all of the facts as true. And I think there's some serious leaps in there. That's a different issue. Fact questions are reserved for trial. We're talking about legality. So if you take the facts asserted in this pleading as true, you can say, okay, I see how this conspiracy that they've written about has unfolded, but what I don't see anywhere is him saying Donald Trump and Rudy Giuliani met and agreed to this course of action in this way. They contacted the Proud Boys and the Oath Keepers in this way to get them to agree to the conspiracy. The closest thing they have is Donald Trump answering a question at a debate that was prompted by the debate moderator, which was, what do you have to say to white supremacists? And that devolved into denouncing the Proud Boys. And he said, stand back and stand by. And then the head of the Proud Boys tweeting, standing by, sir. That is the totality of evidence that they have provided that Donald Trump worked with the Proud Boys. And they don't have anything about working with the Oath Keepers at all. But that is it. That is the total link of the conspiracy in the facts section, that Donald Trump answered a question at a debate where the Proud Boys were not, and that one member of the Proud Boys, their leader, Tario, that he tweeted, standing by, sir, that is the evidence of their conspiracy. And to me, that we can take all of that as true, and still say that is not a meeting of the minds in furtherance of a conspiracy in any way to deprive Bennie Thompson or anyone in Congress from interfering with their civil rights. They certainly did not do that contemplating the January 6th events, and it's ludicrous to assert that they would. But because of that failure, no meeting of the minds, no agreement to a conspiracy, not even pled in the complaint, I still believe that this will fail. Now, I hate doing correction videos. You won't see very many of them because I do try to be pretty thorough in my research, and this one did slip by me. So I wanted to put that out there. Please drop a comment below. Tell me how terrible I did and all of that stuff, and that's great. Also, tell me what you think about this, and we'll see you soon. Have a good day. Peace. Peace.